First is I acknowledge the ancestors of the Cheyenne, Arapaho, and Ute people on whose land we're meeting, and I acknowledge their sacrifices so that this city and this state can be here. To give you a little background for those committee members who went on the committees last year, my name is Glenn Morris. I'm guilty. I am a professor of political science, a tenured professor of political science at the University of Colorado at Denver, where I hold the permanent title of President Teaching Scholar, which is the highest research and teaching award bestowed by the University of Colorado. I'm also a graduate of the Harvard Law School, and I serve on governing boards or councils for a number of organizations, including the Four Winds American Indian Council and the Leadership Council of the American Indian Movement of Colorado. My father was a member of the Shawnee Nation, and my mother, just to set the record straight, was from County Tipperary, Ireland. She was an Irish Catholic. I was a baptized Catholic. She was a devout Catholic until the day she passed away. But now I practice the traditional ceremonies of my father and my family. I've researched and published about Columbus and the legacy of Columbus, as well as the origins and celebration of Columbus Day for over 30 years. And so I had intended really to talk about what the nature of state-sponsored celebrations and holidays is in a democratic, pluralistic society, but I heard a couple of comments from the panel and wanted to address a couple of them. One has to do with Representative Valentine's point about the doctrine of Christian discovery, and that's not my terminology, that's the terminology of Chief Justice John Marshall in Johnson versus McIntosh, and also the question about historical revisionism, because I think that's an important question for us to ask. How does history get written? How does it get transmitted to future generations? And I've done a lot of work about Bartolome de las Casas and about his contemporaries, and I'd be glad to talk about that, because I know that there are a number of lawyers on this panel, and one thing I'd just like to say about Las Casas is that he was a contemporary of Columbus. He was the first historian from Europe in the Americas. He's the first biographer of Columbus. And his testimonies were what the lawyers on the panel will recognize as testimony against interest. In other words, he had nothing to profit from that, and everything to lose, because there was a little episode called the Inquisition going on at the time. And so he had everything to lose, including his life, by providing his testimonies. And so I'm at your disposal, at your pleasure. I'm willing to talk about everything that was talked about today, but I don't want to be too redundant, but I'll be glad to elaborate on any points that have been made, because I know much of the testimony today was a repeat of what many of you on this panel have already heard. With that.
Yes, thank you very much, Professor. We appreciate your testimony, and let's see if the committee has any questions. Representative Benavides.
Thank you, Mr. Chair, and thank you, Professor Morris, for coming and talking to us. I know you attempted to say something about the doctrine of discovery, but could you elaborate on how that impacted the treatment of American Indians in our history?
Professor Morris.
The doctrine of Christian discovery was articulated by John Marshall in 1823. And any of you who have been to law school, most of you in your property law course, the very first case in your casebook is probably Johnson versus McIntosh. But because without Johnson versus McIntosh, there can be no legitimate transfer of property in the United States. Marshall articulated a rule in that case that said, by virtue of the discovery of America by Christian sovereigns, that's his language, not mine, it legitimized a rule of law that said indigenous peoples were only possessed of an aboriginal title, an inferior title to fee simple title in English law. And because of that, the United States, and after the United States articulated the rule, this rule was exported around the world to Canada, Australia, New Zealand, every English common law country in the world that said invading, they called it discovering, invading European Christian sovereigns had the right to dispossess Indian people, indigenous peoples of our territories, and supplant that possession with their perfect title. And so that essentially diminished the ability of indigenous peoples to live on our own territories, where we lived from time immemorial, and give it the sanction of law. And so that case has that thread from that case, and Marshall reaches back to Columbus to find this rule, and the papal bulls that were talked about earlier. And so the legitimacy for that rule in Johnson versus McIntosh comes from Columbus directly. And so the case law that has been produced since that time, and I can go through the whole litany of cases up till 2005, where the Supreme Court in City of Sherrill versus Oneida Indian Nation cited Johnson versus McIntosh for the legitimate dispossession of the Oneida Nation in New York, 2005. So the legacy of the doctrine of Christian discovery is alive and well. As Dr. Green mentioned, in the Kumeyaay case in 2015, the district court in California also cited Johnson versus McIntosh in its ruling. And so the legacy is long, but once you dispossess a people, an independent people of their territory, then it's downhill from there. Because their ability to exercise self-determination, to exercise independence, to exercise cultural integrity, religious freedom, all of those things are diminished. And we've seen that repeatedly after the rule in Johnson was articulated by the court.